All right, let's get right into it. We're going to talk about one of the most powerful and, yeah, one of the most controversial tools in Canada's entire constitution. It's called the Notwithstanding Clause, and it gets right to the heart of a massive democratic debate.
And that debate really boils down to this one question. When it comes to our most fundamental rights and freedoms, who gets the final word? Should it be unelected judges who interpret the Constitution? Or should it be the elected politicians that, we actually vote for? This is the core tension we're going to unpack right now.
So, to really wrap our heads around the Notwithstanding Clause, you first have to understand the two major powers it's meant to balance: the power of our courts and the power of our parliaments. Think of it like a constitutional tug of war. On one side, you've got the courts. Because of the Charter of Rights and Freedoms, they have the power to look at a law and say, nope, this violates our rights, and strike it down. But on the other side, you've got this huge principle called parliamentary sovereignty, which is the idea that the people we elect to represent us should have the ultimate power to make our laws. So, what happens when those two massive powers pull in opposite directions? Well, that's exactly where Section 33 of the Charter, the famous Notwithstanding Clause, comes into play. It was created specifically to be the referee in this tug of war. So what is this thing, really? Well, in a nutshell, the Notwithstanding Clause gives a government, either federal or provincial, the ability to pass a law that works in spite of certain charter rights. It's basically a way for an elected legislature to say, okay, we've heard what the court has to say, but we disagree, and we believe this law needs to go forward anyway. And you gotta understand, this clause wasn't some kind of afterthought. It was a huge, deliberate deal. Back in 1982, when the charter was being hammered out, some provinces were really worried about giving too much power to judges who aren't elected. So Section 33 became this great political compromise that balanced the power of the courts with the power of the people's elected representatives. But here's the thing, it's not a blank check. The clause can only be used on very specific rights. And we're talking about some heavy hitters here. Fundamental freedoms, like your freedom of expression and religion. It also covers most legal rights, like your right to life, liberty, and security. And it applies to equality rights, which protect us all from discrimination. So yeah, these are absolutely critical protections.
On the flip side, some rights were considered so essential that they were made completely untouchable. They're totally shielded from the clause. These include our democratic rights, like the absolute right to vote, our mobility rights to live and work wherever we want in Canada, and our official language rights. The creators of the Charter basically built a fortress around these.
And here's maybe the most crucial safety feature. Any law passed using the clause has a built-in expiry date, a 5-year ticking clock. After 5 years, that law is dead, unless the government deliberately chooses to pass it all over again. This pretty much guarantees there will be an election before a government can renew it, giving all of us a chance to have our say at the ballot box.
Okay, so this brings us to a really fascinating idea in Canadian law, the constitutional dialogue. Instead of just seeing this as a power struggle, many experts see the relationship between our courts and our governments as a kind of ongoing conversation about what our rights mean. So how does this dialogue actually play out? Well, it usually starts with the government passing a law. Then a court might look at it and say, hang on, we think this violates the Charter. At that point, the ball is back in the government's court. They can say, okay, you're right, and change the law. Or they can play their final card, invoke the Notwithstanding Clause, and in doing so, have the final word in that conversation. As you can probably guess, this kind of power is at the very heart of a massive, ongoing debate. Is the Notwithstanding Clause a brilliant tool for democracy, or is it a dangerous threat to our most basic rights? The arguments on both sides are really strong. The case for the clause is all about democracy. Proponents, like this legal scholar from Osgoode Hall, argue it makes sure that at the end of the day, the people who make our laws are the ones we can hold accountable in an election. It's seen as a necessary check on the power of unelected judges. But the case against it is all about protecting our rights. A former Supreme Court justice once called it a safety valve, something that was only ever meant to be used in really rare and unusual situations, not as a go-to political tool for whatever a government wants to do. So if you boil it all down, the whole debate looks kind of like this. On one side, people say it upholds democracy and ensures politicians have the final say. On the other side, people worry that it weakens our fundamental rights, could be used to harm minority groups, and puts politics above the rule of law. So where does all this leave us today? Well, that constitutional dialogue is anything but over. In fact, it's a living, breathing, and often fiery debate every single time the clause is even mentioned.
And let's look at how it's actually been used, because some of these facts might surprise you. First off, the federal government has never once used it. Ever. But several provinces have, and each time it sets off a national firestorm. And maybe the most shocking fact of all, the courts have said that a government doesn't even have to give a reason for using it. They just have to say the words. So the bottom line is this. The Notwithstanding clause isn't some dusty, forgotten piece of history. It is a live wire in our Constitution. It forces this constant, sometimes uncomfortable, but absolutely necessary conversation about where power really lies in our democracy. Which brings us right back to where we started. The existence of this clause forces every one of us to think about that fundamental question. When it all comes down to it, who do you trust to have the final say on our rights, the courts or the politicians? There is no easy answer, and that's exactly what makes Section 33 so incredibly important and so endlessly controversial.